Following today's webinar, we will send you all a copy of the slides which contain my contact information. Please do not hesitate to contact me should you have any questions you would like answered online. In terms of format, what I would like to do is firstly give an update on the continuing feed-in tariff saga in relation to solar PV, followed by an overview of the content of phases 2A and 2B of the consultation. First, however, I thought it would be useful if I put the feed-in tariff scheme into context through sharing with you some of Ofgem statistics. As at the 31st of December last year, just over 147,000 renewable installations were registered under the scheme since its implementation. Almost 36 million in FiTS payments were due to generators in the last quarter ending on 31st of December. PV installations represent the vast majority of newly registered installations at over 99% of all installations registered in the last quarter. And it's interesting to note that this was the largest uptake of the scheme since it started in 2010 at over 65,000 new installations. Finally, PV makes up 90% of the total installed capacity registered under the scheme since its implementation. So what is the comprehensive review? Well, many of you will be aware that the comprehensive review was first announced last year and is being undertaken a year in advance of the original schedule. This is in addition to the fast-track review of the large-scale solar PV which took place last summer and which resulted in reduced tariffs for solar PV schemes of 50 kilowatts and above with effect from 1st of August. The comprehensive review is being undertaken in two phases. The first phase, and arguably the most controversial phase relating to solar PV tariffs, closed on the 23rd of December last year. The response was published on 9th February. The first phase consultation attracted a total of 2,393 responses, of which, unsurprisingly, 81% disagreed with the new proposed tariffs and the proposed reference date of 12th December. Phase 2 opened on the same date as Phase 1 was published, with Phase 2A closing on 3rd April and Phase 2B due to close on the 28th of April. So on to the saga. Last October, the government published a consultation which controversially proposed to cut subsidies for solar PV installations by up to half in some cases. The controversy focused on the fact that the government had proposed that such cuts would apply to installations accredited on or after 12th December last year, a date which fell before the consultation had even closed. This proposal caused industry uproar on the basis that if passed, the proposal would be, and I quote, a retrospective alteration of the scheme which confers a vested right to a fixed rate. As you may know, under the scheme, once an installation is accredited, it becomes eligible for payment of the tariff in force at that date for a maximum period of 25 years. This is subject only to fluctuations in the RPI, although that may change under the current consultation. As a result, a case was immediately lodged against the government on the illegality of the proposal. The government lost the initial case and immediately appealed against the decision, but on the 25th of January this year it was announced that they had lost their appeal and had further been refused permission to appeal to the Supreme Court. The judges in that case unanimously decided that the government had no power to, and I quote again, introduce a modification which reduced a rate fixed by reference to an installation becoming eligible prior to the modification. They said that to do so would be to take away an existing entitlement without statutory authority. Notwithstanding the fact that 3 High Court judges advised that the government would not be granted leave to appeal the decision, the government decided to pursue this course of action anyway. And forecasters suggest that there is only a remote chance that the government will be allowed a hearing in the Supreme Court, and if so, it could take up to a year before their case is heard. The saga therefore continues, and as a result, the uncertainty remains. As anticipated, the response notes that from 1st of April this year, solar installations with an eligibility date on or after the proposed current reference date of 3rd March will receive the new lower tariffs from 1st April. The government is however still reserving the right to change the reference date to 12th December last year if they win their appeal to the Supreme Court. This means that developers of installations that are to be installed between 12th December last year and 2nd of March this year still have no clarity as to which tariffs apply to their scheme, and they'll have no such clarity until the Supreme Court appeal is put to bed. I was at an event this week which was hosted by Smartest Energy, where DEC confirmed that if the government revert to the 12th December reference date, they will not allow any clawbacks of tariffs already paid. The cuts will only be effective from the date the law is changed. So this at least gives some comfort to developers who are caught up in the turmoil. As proposed, generators with an eligibility date between and including 3rd of March and 31st of March this year will be eligible for the current tariffs in respect of electricity generated in this period only. They will then move on to the new lower tariffs from 1st of April. Within the response, the government has also strengthened the link between subsidies and energy efficiency by declaring that properties installing solar panels, including extensions, on or after 1st of April must have an Energy Performance Certificate rating of D or above to qualify for the full FiT. The rating of D or above is an improvement from the originally proposed EPC rating of C or above. The good news with this is that the government predict that half of all dwellings are currently able to meet the D rating or above, and they're also hoping that schemes such as the carbon emissions reduction target and the Green Deal from autumn will be able to help fund improvements of the remaining dwellings to reach the required D rating. Those that cannot meet rating D will only be entitled to a lower tariff, which is currently proposed at 9p per kilowatt. Buildings which cannot obtain an EPC certificate will be exempt from this requirement, but this will only occur in limited circumstances. Also from 1st of April, a new multi-installation tariff will come into force for solar PV installations only. The rate is forming part of the Phase 2A consultation and is currently proposed at 80% of the standard tariffs. The multi-installation tariff will be introduced on aggregated schemes where the FiT generator or the nominated recipient owns or receives FiTS payments from more than 25 installations on different sites. Just to note that for less than 25, the individual rate will still apply. Connected persons will be taken into consideration when aggregating the number of installations, and the government has committed to using the definition of connected within section 1122 of the Corporation Tax Act 2010. This definition is quite lengthy, so I'm not going to put it on a slide, but will circulate it along with these slides following the seminar. As I already mentioned, the purpose of Consultation 2A is to set out the government's proposals to propose new generation tariffs for installations with an eligibility date on or after 1st of July this year, and to follow Germany's lead and set out a programme for the digression of solar PV tariffs. The consultation is due to close on 3rd of April, so any responses should be received before then. It's interesting that the government has chosen to follow Germany's example, given that since phases 2A and 2B of the consultation have been launched, Germany have made radical unplanned changes to their FiT system. The result of Germany's most recent changes has caused major upset and uncertainty from the solar PV industry's perspective, and is resulting in a huge cut going ahead a month after the announcement, followed by a range of measures including monthly tariff digression. Also, they're intending capping the capacity of eligible plants and capping the amount of generation that will be supported by tariffs to between 85 and 90%. Let's hope the UK government doesn't go further and follow Germany's most recent changes to the FiT scheme, or even further uncertainty would be brought to the UK market. Following the recent controversy surrounding the cuts to the tariffs available for solar PV, the government is consulting on implementing further cuts with effect from 1st of July this year. The government are looking to set tariffs that track the cost of installation changes in the market to give a fair rate of return, and also to ensure that tariff expenditure can fit within the government's budget. As a result, it is proposed that the new tariffs will be based on the actual level of deployment of installations in March and April, being the first 2 months of the new tariff scheme, and the government is seeking responses on the rationale and future plans for this scheme. Following the new tariffs being put in place, the government proposed that a baseline digression programme will be implemented. The baseline digression programme will develop a system whereby a trigger is reached when deployment of solar PVs reaches a certain level, which is to ensure that subsidy levels keep in step with the market. The purpose being that the available tariffs will be lowered in line with the decline in costs involved in installing PVs. It is proposed that the first tariff reduction will take place in October this year, when tariffs will be cut by 5%. Tariffs would then be cut by a further 10% every 6 months thereafter. The consultation is seeking views on whether a level of baseline degression of 5% every 6 months would be a more accurate reflection of the expected decline in deployment costs. Under the programme, DEC will publish a timetable of expected deployment figures of solar PVs and will also publish monthly figures showing actual deployment levels against this. If actual deployment exceeds 125% of the expected levels before the date of the next planned baseline degression, which occurs every 6 months, then a contingent degression would occur. A contingent degression is where tariffs are adjusted automatically when the actual deployment figures breach the expected figures. When this happens, DEC will make an announcement and the new lower tariffs will take effect 2 months thereafter. The government is also seeking views as to whether it would be appropriate for different degression triggers to be implemented for different bands. There are 3 types of band currently being proposed. Domestic band, which is up to 10 kilowatts, small commercial between 10 and 50 kilowatts, and large commercial over 50 kilowatts. Within this consultation, the government are also considering whether the levels of degression should change once the 2 ROC rate has been reached, whether the 80% tariff rate for multi-installations is an appropriate level, and whether the standalone rate of 8.9 for those installations not meeting the energy efficiency conditions is appropriate. They also consider reducing the lifetime of a tariff to 20 years, whether the level of export tariffs continues to reflect the real value of FiTS exports, and whether tariffs should be changed from real index-linked tariffs to nominal flat tariffs for individual installations. Please note that this is also being consulted on in relation to other technologies in Consultation 2B. Finally, you should also note that any of these changes would only apply to new entrants to the FiTS scheme. The purpose of Consultation 2B is to review the FiT rates for technologies other than solar PV and also deal with various administration issues. It covers a wide array of topics, so I will only focus on some of these today. On to the new tariffs. Under the consultation, DEC are proposing to introduce new tariff rates from 1st of October this year. They are seeking views on these rates as well as the timing. In order to ensure value for money for energy consumers and that FiT spending stays within the levies control framework, the government is proposing to set an upper limit of 21 pence per kilowatt for generation tariffs. This has been based on the highest level of tariffs proposed for solar PV that were introduced in the Phase 1 review. The following tables show the current tariff against the proposed tariffs from October this year. As you can see from this graph, there are no real drastic changes for hydro projects, and I've heard from industry that they are generally happy with these proposed tariffs. Again, there is no real change here other than to large-scale AD, which has been reduced from 9.9 to 9p. Again, the reason being is the government's attempt to encourage deployment of AD facilities without the United Kingdom. The rate of reduction for wind fluctuates, but as you can see, the most significant reductions are to small-scale wind. I understand that the small-scale wind industry is unhappy with this proposal and feel that their tariff should be greater than that for medium-sized projects between 15 and 100 kilowatts. The reason being is that the returns for medium-sized projects are generally much greater than as for small wind. Small wind developers are often individuals who have no access to finance to fund the project and as such should be compensated in the form of tariffs which would encourage deployment among those individuals. The only technology to buck the decline trend is micro-CHP. It is proposed that the tariff is raised, and again, this is an attempt by the government to increase deployment of this technology. Consultation 2B also seeks views on how the principles for cost control mechanisms as set out in Consultation 2A should also apply to other technologies other than solar PV. DEC are proposing that the principles applied to solar PV should be applied flexibly across the board of technologies. This would include a baseline rate of degression as well as contingent degression through capacity-based triggers. The tariffs would be subject to a minimum degression rate of 5% per annum starting in April 2014. The capacity-based triggers for technologies other than solar PV will have a longer notice period of 3 months rather than the 2 proposed for solar PV. The degression and triggers will not apply to micro-CHP. The problem I see with using the solar PV model of digression of other technologies is the fact that, unlike solar PV, the other technologies have not breached nor even met their projected levels of deployment through the FiTS scheme to date. It may be that for other technologies, only capacity-based triggers rather than baseline digression is relevant. As you may know, it's a long-term goal of the government to apply the energy efficiency requirements as proposed in Phase 1 of the consultation to all technologies. However, it's slightly more complex than for solar PV, given that many technologies, for example hydro and large-scale wind, have no direct link to buildings. The consultation questions whether energy efficiency requirements should firstly be applied to some or all technologies other than PV, and secondly, whether EPC requirements should apply to small wind generation where they are mounted and to micro CHP. The government are proposing that this concept will be revisited in the future after the energy efficiency policy has been decided, including the Green Deal. Now, the fact that the government is looking to revisit this issue creates more uncertainty within the industry. Surely they should allow for a period of stability before they change the goalposts again. Following on from Phase 1 of the consultation, some of the responses, including from a number of stakeholders, suggested that generation from certain installations and communities should receive preferential treatment in order to reflect the wider benefit they will bring. As a result, Consultation 2B is seeking to provide greater certainty and help for community projects and seeks views on the definition of community installations. In developing such a definition, the government are trying to make sure it targets the correct groups, it is not too wide, and can be legally implemented and enforced. The key areas the government are targeting under the definition are social enterprises, charities, and social housing. The government found in the past that some developers were using the term community far too loosely in order to gain benefit and are thus trying to combat this in the future. I believe they will have to find a balanced definition here in order to avoid those projects which have a community benefit losing out, as a result of them not being community projects in the legal definition. It is also proposed that community multiple installations should receive a higher rate of multi-installation tariffs than non-community owned installations. This rate would need to reflect the cost advantages of multi-installation projects over individual projects. The government is therefore proposing that where there is a community-owned multi-installation, they will receive 80% of the tariff offered to generators with less than 25 installations. As you will remember, I previously mentioned that the threshold for multi-installations will be 25. Therefore, smaller scale multi-site community-owned projects would be treated separately and still receive the full individual rate. DEC are also consulting on the applicability of a fixed tariff at some point in a project's process to provide certainty in the same way that preliminary accreditation can. It is proposed that this fixed rate would apply for those projects coming under the definition of community and would last, for example, a period of 6 months. DEC are welcoming views on how to help community projects, and views are not to be restricted to the boundaries of the FiTS system. Obviously, the government will need to think about how to administer this carefully, as they will want to avoid a situation whereby lots of community projects are granted fixed tariff without going ahead, but still triggering early digression. In relation to eligibility, the consultation asks whether the current 5 megawatt cap remains the appropriate limit or whether a lower limit should apply. It also suggests that no new other technologies should be supported under the scheme. Interestingly, at the event I was at and mentioned earlier this week, a DEC official noted that the FiTS scheme was only ever set up to raise awareness through the distribution of renewable technologies and was never meant to support professional developers. It's interesting, therefore, to reflect on the level of the cap, given that I can't ever imagine a non-professional developer developing up to 5 megawatts. It makes you wonder what the government were thinking. As you may know, the renewables obligation, which runs parallel with the FiTS scheme, provides an option for pre-accreditation, which can provide applicants with more certainty. A number of stakeholders have called for a similar feature within the FiTS scheme. In order to create the much-needed certainty for the renewables industry, the consultation also proposes that a preliminary system for FiTS should be created for all RUFIT installations. The government is also proposing to set a fixed tariff for a set period of time for those installations that have been pre-accredited. That way, they will not be affected by any changes, which will provide certainty for that project and in turn help secure investment. In order to implement the pre-accreditation process effectively, DEC are also considering how long the fixed tariff should last for, if there should be a penalty for uncompleted projects to prevent speculative applications, and at what stage the installation could be eligible and how long the guarantee of the tariff should last for. I've heard from industry on a number of suggested proposals, like having a pre-accreditation fee that is prohibitive, which will deter speculative applications. However, if the fee is too high, financing again could be an issue. Another suggestion was to only allow pre-accreditation to be achieved once a milestone in the project has been reached, for example, the planning stage on a wind project. The consultation also takes a look at the accountability of the scheme as it currently operates, including the relationships between DEC, Ofgem, MCS, electricity companies, generators and installers. DEC are considering whether Ofgem should be able to attach conditions to accreditation to deal with instances when fraud may be discovered after accreditation. However, to render this effective, Ofgem may require additional powers to enforce those conditions against fit generators, including rights of access. Linked to this, it may be appropriate to grant additional investigation and enforcement powers for Ofgem, for example, to ensure that FiTS are not paid for installations that are operating unlawfully. Some of the other points the consultation is also looking for responses on are in relation to licensing. DEC are proposing that the level should be changed to 250,000 customers for mandatory participation in CERT and CESP. They are seeking clarification on the definition of site to address issues raised by hydro installations and installations on private wire networks such as mobile homes. Industry are hoping that clusters of hydro sites will be allowed to be classed as individual sites, notwithstanding the fact they are connected to one MPAN. This will make the more tricky developments more feasible. They are also looking for details as to whether MCS should be the route for FiTS accreditation for microgeneration, or if there should be another scheme. They are looking at issues around a replacement for MCS accreditation for microhydro, and also whether the principle of a voluntary approach to ensuring sustainable use of purpose-grown crops in AD plants that benefit from FiTS. As you can see, phases 2A and 2B of the consultations cover a lot of areas, which goes one way to show how the government is attempting to streamline the feed-in tariff scheme as a whole. Over the last couple of months, as a firm, we have seen that the uncertainty has affected many projects, with developers being unwilling to contract until they can be clear which tariffs they are getting. This has, of course, impacted on their ability to raise finance in some instances, as investors are simply not interested unless the feasibility of a development can be established. We have, however, had a number of developers who have proceeded with their project regardless. Taking the Carpe Diem approach, these clients have decided that the feed-in tariff they receive, whether reduced or not, will make only a minor impact on the feasibility of their project. There's still money to be made in feed-in tariff scale projects, and they are keen to benefit from this. I think that going forward, timing will remain a main theme in the scheme, as developers try to time their accreditations in line with benefiting the most from the digression programmes. Developers will thus have to become ever more market savvy, monitoring DEC's publications as to the timing of the reductions. A running theme throughout the changes is a link to energy efficiency. Granted, this is easier where the technology is linked to a building, like in the case of solar panels and microturbines. However, I feel that the government will have a great challenge trying to make the link between this and other technologies. I think it's definitely an important link, but I feel that the government will find it challenging to establish. I would particularly welcome your thoughts on this issue. From a personal perspective, I am also keen to see that the government is trying to benefit community projects through a number of measures. As it stands, less than 1% of all renewable energy is generated by communities, which I feel is a shame given the potential here. We need to tap into the potential of the communities market to enable communities to transform themselves and assist in meeting the government's renewables targets. Now, thank you for listening to the main part of my talk. I will just check whether any questions have come in. We have one question which has come in so far, which is from an anonymous party. They have asked if it's a point in relation to the multi-installation tariff, and have asked whether the new lower tariff would apply to all installations if they exceed 25. In terms of the consultation and how it is worded, my understanding is that the lower tariffs would only apply from the 26th installation onwards. This would mean that all 25 up to that rate would still have the original higher tariff, with the 26th and onwards being only entitled to the lower tariff. I think that's all the questions we've come on just now. We might be having some technical difficulties, but if there are any further questions that come in following this, I will distribute them with answers along with the slides. So I'd like to take this opportunity to thank you very much for listening to the webinar today. I hope you found it useful. Again, if there are any other issues or questions you would like to discuss with me offline, please do not hesitate to contact me. You will see my details are on the final slide. Thank you very much and have a lovely afternoon.